these horror stories about disputes that involve big estates, millions of dollars. Okay, those people, they're the ones with the problem. That couldn't be the furthest thing from the truth. I've dealt recently with an estate that the people were fighting. Literally, there was $10,000 in the estate. There was a candelabra, a few silver goblets, and a menorah. And there was only 2 children. And they were on good terms before, and they were not talking to each other. Baruch Hashem, I was able to work it out. But don't think that anyone's above it. I happen to be familiar with the person, and he's a good person. Something about when it gets to Yerusha, they're looking for, it's an emotional attachment to their parents, whatever it may be. It doesn't always bring out the best in people. And especially true if there's an underlying, not harmonious relationship between the siblings. This is the place where we'll be exasperated, we'll be brought forth, and it's something that, once there is a fight, it's something very difficult to bring under control. But if someone has the foresight and sets up his estate to avoid this conflict, it's something that's very easily done. If I went around this room and I asked people, most people here, I imagine, are still working, or they worked for a big part of their life, like why they worked so hard and they were trying to earn money. A big part of it, probably, they'll say, they wanted to do good for their kids. They're working not only for themselves, they probably had it, they were financially okay. They're working because they want their kids to enjoy the fruits of their labor. If someone does not go ahead and do proper estate planning, his whole life's work, and a big part of it, where he's trying to do good for his kids and leave them over money that they should be able to enjoy and to do the right thing with it, that could be the underpinning of conflict and lose the whole family. That could be in tremendous machlokes, tremendous strife, people not talking to each other. And even if it doesn't rise to that, not always does it come to the surface that it causes an obvious machlokes, an obvious fight, but there's underlying friction which is not healthy. So a person, if he does the right thing and sets up his estate with clear instructions, realizing what's important, how to set it up, again, within the confines of halacha, how he should do it. But if a person goes ahead, and that's why it's important that someone should not just leave it up for a chance, that everything is going to work out. And if he has a situation, which many people do, where it's not 100% straight. He has one child who's in the business, and the business is now running. Does that child get the whole business? What's going to happen with that? Sometimes people have a particular heirloom. That's something that's valuable to them. Leaving out any of these things, if someone does not do proper estate planning and give clear instructions, as difficult as it is to sometimes head on and to say, I'm going to get involved, I'm going to decide, this kid should get this kid should get that, this kid should get this percentage of the business, I want my business to work like this. As difficult as it is, it's more difficult not to. Because at the end of the day, if you leave clear instructions, the children will not fight about it. It's there, it's done, it's finished, finalized, they'll accept it. If you do not leave clear instructions, you're asking for it. There's once, a big Dayan told me once that there's not one single fight of Yerusha that's not the parents' fault. They didn't set it up, or they tried outsmarting the system. We'll see that some people are smarter. They think they know better than what the Torah said, how to set it up. Or that's also could be a room to promote conflict. That we'll see what the proper way of how the Torah's hashkafa of how someone should set up his estate. But if someone follows the tried and true divrei Chazal of how to set up one's estate, he'll do a tremendous service to his family and potentially avoid a machlokes. Now, I'm not getting up here and saying that anyone who doesn't do it means that their kids will definitely fight. Furthest thing from the truth. Most times, it's true that people will not fight. But, like we said, this is the most important thing. You want harmony in the family. Don't leave it up to chance. Make sure to go ahead and to set up an estate that it could avoid conflict. So that's the first thing, just a basic outline as to why it's important that someone should go ahead and to do proper estate planning. The second topic that we'll deal with is what's the proper way, according to the Torah, how one should divvy out his estate. As we mentioned earlier, a daughter is not a Yerush, a wife is entitled to full support from the estate, but ultimately they don't Yarshin. Sometimes people have stepkids, also according to Halacha, they don't Yarshin. And the question is, we'll see as to how the right way, according to the Torah, is to set up and to give out those estates. We'll see that there's an Indian not to change between one kid and another kid. Sometimes one has a child who's affluent, he made it, he has a big business, he made a lot of money. The other child is struggling day to day, he doesn't make ends meet. Is it proper to go ahead and to give the child who's struggling on a day-to-day basis more of the estate and to sort of take away from his sibling, which doesn't really need this, so doesn't need this Yerusha? So we'll go through the proper Torah hashkafa on that question as to how one should go about setting up his estate. And the third thing we'll deal with is how is the way to do it that it's actually enforceable. Most people will go to an attorney, they'll go ahead and to write a will, a civil will, that's enforceable in court. And this is not a new thing, that people relied mostly on a will and did not go ahead and write a halachic will. In Litta, the Chaim Oizer wrote that the minig was to rely solely on the secular will. We'll see Moshe Feinstein has a tshuva that upholds a civil will. But we'll also bring, and we'll see that this is not a davar pasha, it's a machloikas this, it's not set in stone, it's not settled halacha, that a will be enforced in Bezdin. I myself spoke to Reb Nissen Karelitz Zatzal and asked him if they came to your Bezdin and someone produced a civil will, would you uphold it? And he said, I wouldn't give him anything. So again, as we mentioned before, a person's outlook when he's setting up his estate has to be that he's trying to avoid any strife, he's trying to avoid that there shouldn't be any machloikas. So whether or not you are of the opinion that a civil will should be enough, it's not necessarily a wise idea to rely on it, because you never know. Someone could be not, usually go with Moshe Feinstein's psak, but when there's money dangling in front and he sees reasons why all of a sudden he should move on to another person's perspective, another person's halachic opinion, sometimes the negias of money will transfer him and he'll actually all of a sudden come to the realization that he goes to a Bezdin, they'll challenge the will, they won't challenge this will. So there's a simple steps that we could outline as to what one can do to make the civil will enforceable according to halacha without giving someone the ability to go ahead and to challenge that will. But let's go just back for a second, what we mentioned earlier. What happens if someone does not go ahead and write a will? What happens if someone, and some people have a difficult time dealing with estate planning, it's an uncomfortable place to go, and they don't do anything? What will happen then? So as we mentioned before, according to the Torah, person has a son, he will yarshin, the sons amongst themselves will yarshin the estate. Their mother will not be entitled to Yerusha, entitled to live off the estate, she'll be entitled to Iksuba, but she won't actually get all the assets, and she'll sort of have to rely and deal with the children because they are the halachic owner of the estate. They have a requirement to support her, besides that it's their mother, and they have a requirement that's kibbutz maybe, but that's not, we'll see exactly what that part of it. But just they have a requirement because of their husband to support the estate, the remainder of the estate has to support the wife, but it's not going to be their money. The mother won't be able to do whatever she wants. She won't be able to give gifts necessarily above and beyond what she was used to, accustomed to in her life before. And many people feel the wife was there at their side. I'm sure everyone will agree to that on that side, that they should be entitled to more of the estate. And the question is, if a person doesn't want to write a will, they will not be entitled to that according to halacha. Now, and also we mentioned a daughter does not yarshin one's father. There's an interesting Magid Maysharim, which is for Shavuos. We all know this famous story of how the Magid appeared to the Bais Yosef on the night of Shavuos, and that's why we have the minhag to stay up Shavuos night. But the Magid used to come pretty often to the Bais Yosef. A Malach came to the Bais Yosef and he used to teach him Torah. And there's a sefer called Magid Maysharim, which the teachings that the Magid taught the Bais Yosef is quoted in the sefer. And he writes in that sefer, the Rosa de Nachla, the Seid, the hidden mystical things that go on with Yerusha, Rosa Amika, is a very hidden, deep thing. It's not for naught that we'll see that there's an Indian that you should not actually go ahead and to switch around to say the Yerusha. And the reason why a son yarshins and the reason why a daughter does not yarshin is a very deep hidden thing. Not chas v'sholom because the Torah does not honor a daughter equal to a son. It's not chas v'sholom any lack of chashivas for a daughter and a more chashivas to a son. They're hidden things that sometimes that we can't necessarily comprehend, but that is the reality. The reality is that a daughter does not yarshin and a son does yarshin the estate. So therefore, it's important, as you mentioned, that someone should set up his estate by doing estate planning. Some make the argument, listen, we live in America, we're all aware of a concept called Dina de Malchusa Dina. Why do I have to set up my estate? According to the state, if someone does not go ahead and write a will, they probate, there's a seder of how they give it out. Usually I believe it's in, I don't know, in Florida and other states, it's 50% to the wife, the rest goes to the kids, but there's a seder, not like that. Okay. Depends on how the size of the estate. Depends on the size, okay, whatever. But there's a seder as to how they will go about and give it. So will we sort of say, okay, it's not so bad if I don't go ahead and write a will. There's a concept of Dina de Malchusa Dina. The law of the land is governed and it's enforceable even according to halacha. The concept of Dina de Malchusa Dina is one of the most misunderstood areas of halacha. Some believe that it doesn't exist, and some believe that it exists to the point that there's no halacha. There's different spectrums depending on where you grew up, depending on other factors, as to how people look at the Indian of Dina de Malchusa Dina. But there's a Ramah that discusses specifically in regard to Yerusha that we do not apply Dina de Malchusa Dina. The Ramah in Siman Shin Samach Tes, and the Hilchos Gzeila says like this. The Mesa L'Yarsha B'Haila, it's discussing that there was a minhag and there was a Dina de Malchusa that a wife yarshin. We don't say Dina de Malchusa like that. The Leka B'Zeh Mishum Dina de Malchusa Dina. The Lo Yamrin Dina de Malchusa Dina. We do not apply the concept of Dina de Malchusa Dina. Elo B'Dover Sheish Hano L'Melech. I must say a very interesting concept. When do we say Dina de Malchusa? When do we not say it? It depends if it's a benefit to the king or not. That's when we say. Or it's Takonos B'nei HaMedina. So let me just give a, sort of understand this Ramah. Laws as to whether or not we apply Dina de Malchusa Dina can be broken into three categories. The first category is where it's direct benefit to the king. We don't have a king necessarily, but we have a government. The government has to sustain itself. The government has to charge taxes, build roads, fund an army, police force. So that money, and that's why taxes is an area where the Gemara applies Dina de Malchusa Dina. One's requirement to pay taxes, because we do say Dina de Malchusa Dina, because it's direct benefit to the government. Anything that a government needs to tax or a government needs to function, we must always abide by the Dina de Malchusa if it's direct benefit to the government. And even if the government is like a kingdom in Saudi Arabia where they're sort of profiting off the government, but still that's the function of government, the function of anything which is needed, the function of government, we apply Dina de Malchusa Dina. That's the first area. The second area, which is not 100% clear, but there are more actually paskins we do say Dina de Malchusa Dina, is laws that are enacted to benefit society. Public policy, I'll give you an example of this. Come from Lakewood, a big controversy over the past year or two. Post-COVID, the rent basically doubled. Rent became much more expensive. But there's a local Lakewood ordinance that says that there's rent control. So does halacha honor two yidden, one rents a house to another? Would they is it enforceable, the concept of Dina de Malchusa Dina? So here, there's actually a bit of a machlokes. Laws that are enacted to benefit society, we do say Dina de Malchusa Dina. There are those who argue that a place like rent control, is that really benefited in society? There's a tshuva in the Chapsel Shoshani, right? Zemene Kaminista. It's good for the tenant, but it's bad for the landlord. And here we see sometimes as what is the function of government? I once gave a share about, you want to know enough kamina if you're a Republican or a Democrat, rent control might actually be. The Shas Shoshani writes that that's not what government's for. Government's not to take from the poor and to give to the rich. That's a communist government. Communist government is not something which halacha looks at. Others make the argument, no. Rav Henkin and the Tshuva writes, of course we have to do rent control. The purpose of government is to protect the indigent, to protect the people who are less privileged from the rich people taking advantage of them. And that's the function of government. So if government enacts laws which are meant to protect the society, we say Dina de Malchusa Dina. So the second area, again, it might be a question as to exactly what falls under this category. Is Dina de Malchusa Dina where something is enacted to protect society, there we, according to Ramah, we say Dina de Malchus Dina. The third category, and this Yerusha falls under this category, is it protecting anyone? Is it doing anything for anyone? The government happens to believe that the equitable and fair thing to do is that a daughter should yarshin and a wife should be entitled to the estate. Is that something which they mandate? Is that something which they force? It's interesting, if you look at the previous tshuvas which deal with the concept of Avodas Nachla, there's a tshuvas harosh which discusses that someone wants to give to all his sons equally and not go with the Dina de Malchusa, which at that point was that the oldest son yarshins everything. Because that's what they thought was equitable, that way they thought was fair. But more important is the Dina de Malchusa of how the Seder Yerusha should go forth is not something which the government mandates. The government is more than happy if you decide you want to give your sons and not your daughters, or you want to give your daughters and not your sons. They allow that to happen. There's no public policy that the way the Yerusha works should be like this. It's a default. We can't have a society that doesn't have rules. So we're going to do what we think is fair if you don't go ahead and write a will. But it's not something that they're enacting and enforcing that this is the way it should be. Other laws, first two categories, things which are against public policy or things that are to benefit society, yes, they'll enforce that. It's not a waivable thing. So the Seder Yerusha is not something which is Dina de Malchusa applicable, because the government's more than fine if you decide you want to go with a different set of rules as to how it should do that. As long as you don't come to them and both sides are agreeable, that's okay. So therefore we don't necessarily apply Dina de Malchusa Dina. We had an interesting case recently on this Dina de Malchusa Dina. In New Jersey there's a law that if someone's not a licensed broker, he can't get a commission. That's the law. You can't get a commission, you can't earn a commission. There's sort of some public policy in that they don't want people running around that they're brokers and then demanding commissions. You have to be licensed in order to earn a commission on a real estate transaction. So someone spoke to someone and he disclosed that he's not a licensed broker, but he said, you know, I'm demanding a commission anyway, I expect to get a commission. The deal closed, and the person turned around and said, no, sorry, you're not a licensed broker, I can't give you a commission. So they went to an arbitrator who had to deal with this issue as to whether or not the person's entitled to get a brokerage in this case or not. And the arbitrator ruled that he's entitled to get brokerage. The person went to court to challenge it under public policy. It's against public policy. The arbitration award should be thrown out. The judge actually ruled that it's more against public policy to throw out an arbitration's rule than it is that they're going to get it. That means they have no problem if you decide to use a different government, to go with a different body. There's nothing in Dina de Malchusa which prohibits one to go with what the Torah says. When it's against public policy, when it's against laws that are enacted, then they might be conflicted, and that's why maybe Dina de Malchusa Dina applies. But there's nothing about Dina de Malchusa Dina which says that you have to have the Seder Yerusha go the way they do it. If no one does anything, that will be the Seder Yerusha. But that's the first step, that in absence of someone doing any intervention, a daughter will not yarshin, we will not apply Dina de Malchusa Dina, and the son will yarshin everything. Now this is something which obviously most people won't be comfortable with, because they expect that the daughter has an expectation she should yarshin, the wife has an expectation that she should yarshin. But is it proper, is it the right thing to go ahead so you could take care of that problem by writing a will, halachic will, legal will, both, write it the best way? But is that the right thing to do? Well, no. The Torah said that a son yarshins and a daughter doesn't yarshin. Is that correct? Now, to add to why this is the complication of just saying, okay, I'm going to alter the Seder Yerusha from the Torah, there's a Mishnah in Baba Basra, the Kuf Lamed Gimel and Bais. The Gemara says, the Mishnah is like this: HaKosev es nechosav la'achera. If someone writes and changes the Seder Yerusha, and the Gemara says even to a daughter, from what the Torah said, v'niach es bonov, masha osu osu, it's going to work. He could actually go ahead and change the Seder Yerusha if he does it in the proper way. And the poskim say it's not just not ruach chachamim, it's just not a nice thing, not a good thing. The chacham don't appreciate it. It's actually an issa, according to some poskim. And this is brought down in Shulchan Aruch, that someone should not go ahead and to alter the Seder Yerusha because it's ein ruach chachamim noichei menu. And according to many poskim, it's actually an issa. However, I don't think that anyone, any Rav from any community that you'll go to will actually tell you that the right thing today is that someone should not give to a daughter and not give to his wife. So how does that stem with what's said in Shulchan Aruch? So there's basically two steps to this. The first step is, there's a machlokes to how to understand that Mishnah, that a person should not change the Seder Yerusha. There's different shittas in this, but there's a Shuvas Tashbeitz, which says like this, that if a person carves out a certain part of his Yerusha and says, this should go in accordance with the way the Torah said, and it doesn't have to be a lot of money. If Moshe has a tshuva in one place where he writes, it could be even $1,000. Usually we try to do it a little more than that, $5,000, $10,000. He takes that aside and says, this should go according to the Torah, and the rest I'm going to divide the way I think is right. Now, the way I think is right is not because I think right, we'll get to what's considered right, but assuming that he wants to change the Seder Yerusha, that he makes this little carve out. He takes a certain percentage of the estate and says, this is going up to Seder Yerusha. According to the Tashbats, there's no issa then to go ahead and to be Maver Nachla, there's no issa to go ahead and to change it all to the Seder Yerusha of the Torah, as long as he left a certain carve out that should go in accordance with the way the Torah set forth how the Yerusha should work. But that still doesn't tell you that it's right. It tells you that it would work, but it doesn't say that's the right thing. So if a person is doing it, the reason why he wants his wife to yarshin, he doesn't want his wife to have to come on to his kids. He doesn't want he believes his wife served him faithfully all the years. And she should have, very common today, people write reciprocal wills. And that's the way they want the estate to be said. That's okay. Because you're not doing it because you want to change the Seder Yerusha. It's not because you think the Torah is chas v'shalom unjust or unfair. You just want your wife to be comfortable and she should have something. That's a good, valid reason to go ahead and to give it to her. In fact, there are many poskim, the Steichemed, we find that their tzavos actually gave to their wife everything. So it's not a new concept, I'm not trying to tell you something new, but that's an acceptable thing. But again, it has to be for the right reasons. It has to be because you want to make sure she's comfortable, and not because you believe the Torah was unfair, but this is the way you feel that will be best. If you're doing it today because an expectation the daughter has that she will yarshin, that's also a just reason.
How's it okay for us to make the decision? If we're supposed to believe Torah law, and the Torah law is supposed
the Torah law is that. Okay. Torah law is that. That's why Torah. So again, we have the Tashbats that tells us that it's okay to change. It's okay to change what the Torah says as long as you leave a carve out for the estate. Now, it's maybe not Ruach HaChamam Noichim, but what's the choices? The choices are sometimes leaving a situation which can make a machlokes. The Sefer Gesher Achayim, which people are familiar with, was the original Sefer on Avelos, and that was written. He writes, there was a Chosed Echad, a pious person who said, I'm not doing anything. The Torah said this is the way it should go. I'm going to leave it up the way the Torah said. I'm not going to do anything. And he says the machlokes and the Strife that came up from that family was untenable. You have to know what's going on. You have to realize that today there's an expectation. Society expects something. A daughter, and again, there's other reasons why a daughter, it's considered like a dowry. There are other reasons why it's considered acceptable. But there's a minute going back years that it's acceptable for someone to go ahead and to switch from the Seder of the Yerusha with the understanding that he's doing it for the right reasons, that he doesn't want to make machlokes in the family, and he wants his wife to be comfortable and supported fully without having to come on to the children. So this is an acceptable reason halachically, and in fact, a position, although it might seem like a chiddush, that is actually encouraged by almost all Rabbonim across different spectrums. I've spoken to, from Satmar to Bob, different communities, they also encourage that one should give to their daughters almost equal. Again, we have this carve-out, which shows us clearly that we're not saying that they're equal. The carve-out is basically going to stand by and attest that we believe that the Torah is just and fair, and we're not going to be maver that nachla, but it's not going to ultimately affect that. The second part of when one has to decide as to how to divvy his estate is a very interesting Gemara in Shabbos, which a Torah brings in Hilchos Yerusha. The Gemara in Shabbos is like this: Amar Rav, La'ilam al Yeshana bein ben Abana. A person should not give different from one child over another child. Shebeshvil mishkol shnei sloyim shenosin Yaakov liYosef nisgal gladava v'yardav v'seinu l'mitzrayim. It's an interesting thing, and Taisa explains like this: we should give equal to all children, because the Gemara quotes, the Gemara Shabbos says that Yaakov Avinu did not give equal to all his children. He gave Yosef a weird Kseinas Pasan, he gave Mo, and because of that, we were Yered L'Mitzrayim. Now we know that there's other reasons why it was Yered L'Mitzrayim. It was ready with Bris Ben Psarim. It was. So Taisa explains that the hardness of the Sheba, the reason why Klal Yisrael was in Golus and had to work so hard, was because the Aveira Yaakov Avinu did. Again, we're not judging in his Madrega was considered something wrong. He didn't give equally to all his children, and because of that, all the years in exile in Mitzrayim was because of the Avera, he didn't give equal. The Chassam Sofer explains that although you might have good reasons, he says, what did Yaakov Avinu, what was Yaakov Avinu thinking? Why did he, if the din is he's supposed to give all them equal, so why did Yaakov Avinu not give equal? Why did he do that? Sofer explains that Yaakov Avinu had good reason, and his reasons were actually justifiable and correct. So why did he get punished? Zok the Chassam Sofer, because you can't expect your kids to appreciate those reasons. The other Shvatim couldn't appreciate those reasons. So here we have a very important yesod. When someone's taking his estate and setting it up, don't be a wise person. Don't be a wise man. Chazal understood, and there was nenash. When you try changing and making it disproportionate, you could bring machlokes, you bring jealousy, it brings that. The Torah understood that the proper way for someone to set up his estate is to give everything equal amongst each child should get an equal chelik. Again, the Gemara is referring to equal when it's all boys, not girls. But we try to say that, probably say that as well when it's girls. But the Gemara is definitely saying that to give the sons all entitled to an equal chelik, and not to, even though there is maybe a concept, as you mentioned, you leave a carve out, you could alter it. Chazal understood that the strife and the machlokas that could come, and the ulam al yeshana bein ben abonim. I spoke to my Rebbe, Shlomo Miller. He said that even if someone is extremely affluent, I asked him this question. One person is really a multi-millionaire, he has everything that he needs, he has houses, yachts, whatever it may be. And the other one is learning in Kollel and he's struggling day to day. It's nothing doing. When it comes to an estate, don't change anything. Chazal understood, la'olam al yishana be'min abonim, give everything equal. At the same time, he did say that if a person wants to help his kids while they're alive, there's nothing wrong with giving them a little more. You have a son who's a Rebbe, or just struggling financially, and the other son is doing okay. There's nothing wrong with helping him while you're alive, to give him money that he should be able to live, to buy a house. That's okay. But when it comes to the Yerusha and you start changing it, people look to the Yerusha as validation for their parents. And when they see that something was changed, it could cause tremendous machlokas and something that's not proper to go ahead and to do. Now, so that's the second thing that we're saying, is that it's okay to give daughters and a wife, if he's doing it to avoid machlokas, or to give a dowry for other, competent reasons, as long as he makes a carve out. But when giving, besides that carve out, that should be left equal amongst the children, and someone shouldn't try to do it. Now, there are some situations. We are a parent, and this is something that has to be dealt with on a per case basis. We've had Dinei Torah, unfortunately, where a parent moves into a child's house and they build an extension for themselves. Now, what happens to that chelik? Here they went and took care of them all the years. There are sometimes reasons why, as gratitude for that, to give something. I'm not going to say it's absolute without any exceptions. Sometimes of that, but again, in that case in point, we had a Din Torah actually about this. Now, who belongs to that extension? It came from the parents' money. That's something which you must deal with when setting up an estate. And again, we'll see the way to do it is to go to a competent attorney. And it's something that you should not leave out. Anything that could be a question, if you decide how it should get done, there won't be a machlokes. You don't decide, you might end up in Beis Din. It might work as a Dayan, but it's the less people that come to me, the better off Klal Yisrael is. We're not interested in dealing with this, not interested in people having machlokes. And again, it could be something preempted and something that could be done to avoid. Now, how does someone do it? So we mentioned that, a will is a question. Now, the basic premise is there's a concept of a will. Typical will say, I bequeath, I give, which is a lashon of Yerusha, a lashon of how they want their estate to be set up. According to the Torah, if you just said something that how you want the estate to happen, doesn't make it binding. According to the Torah, you have to make a kinyan, you have to actually be maknet. Here you're not giving it to lacha misa, so you could do it in such a way that's right before misa. It doesn't really work for practical reasons, because there are no assets which you don't own at the time when a person sets up a will. Those assets it's not possible to make a kinyan on. So there are a lot of problems in the enforceability of a will, because it's not actually a kinyan, you're not actually giving something over to the children, and therefore it's not simple to say it's halachically enforceable. There are tshuvas from the Binyan Tzion a few hundred years ago, who does actually say that a will, and Reb Chaim Ozer, which you mentioned earlier, said in Litta the minig was to rely on a will, and the basis of that was that there's a mitzvah l'kayim divrei hameis. There's a mitzvah for someone to honor the dvarim of the meis. Now, someone told me once, Rabbi, the estate's worth $10 million. I'm going to keep Chol of Yisrael. I'll do other mitzvahs, but I'll keep the $10 million. But that's not really true. The mitzvah kaim divrei emes is actually something that is enforceable in Bezdin. Bezdin will enforce the concept of mitzvah kaim divrei emes. But there is a problem with the concept of mitzvah kaim divrei emes, is that it actually has to give over to the person who you instructed to give over how to divide the nechassim. You have to actually give it over to him, which is not done. So Chaim Ozer has a unique opinion that the fact that the state will step in and force the will to be done, which is if you gave it over to the person to give it out, the executor of the will is basically given over the estate because the government will enforce it and has to go through it. So therefore, it's considered given over to the executor of the will because the state will step in and it's considered transferred to it. Again, it's a novel approach, something that many poskim will rely on, but it's definitely not 100% foolproof that it will be enforced in the Bezdin. There is a tshuva from Moshe, which he also writes. He has a different approach. Again, I don't have time to go into the exact reasoning that Moshe gave. Moshe does have a tshuva that says that one should honor a will. And he says, even though he gives a very interesting and a novel approach, he says if they're not Nevi'im and they didn't know that they were relying on this reason, B'nei Nevi'im heim. But the bottom line is, he says that a will should be executed, should be enforced. However, as you mentioned earlier, Rabbi Kollel, so I spoke to, told me he would not honor it. Yashav has a tshuva, which he seems in Kavitz Tshuvas, that seems that he does not fully honor and go with everything it said in the will. Therefore, it's not advisable to rely fully on a secular will, especially if there's an easy fix. So let me go through what one can do in order to sort of avoid the possibility of someone challenging a will in a bezdin. I see you have the handout. If you look in the back of the handout, you'll see there's actually a shtar over there, which is a shtar. There are different variations of it, but more or less, they go. The idea is the same idea. And there is a sort of a halachic way to make things enforceable but not enforceable. And if you look at that shtar, it seems like a pretty, that's like a better word, a strange shtar. Here I go and I want to make a will enforceable, and they tell me that I should become indebted to my wife and to my daughters X amount of dollars. What's going on over there? So the concept that's used in that shtar, and again, this is something that's used often, is the Mechaber discusses a concept called shtar chachmei Sfarad. If something is not enforceable from a halachic perspective, we sort of employ this trick to force someone to abide by something which is really, without doing this, would have been unenforceable. Basically, the concept is like this. A person went and set forth, he wrote a will, and he gave a pretty clear directive as to how he wants his estate to be divided. But then again, there's no kinyan on it, there are other problems with it. So I'll do it like this. Let's say just make a simple case. The guy has 2 children, a son and a daughter. And a wife, a son and a daughter. So the son will yarshin everything according to the Torah, and if the will is not upheld, the son will yarshin everything. But he wants his daughter to get equal, minus the carve-out, which you mentioned, the small amount, the money, which is the right thing to do to leave that carve-out. So he does like this. Let's say his estate was worth $5 million. So he tells his daughter, and he writes a shtar to that effect, that I owe you $10 million. Conditional if your brother challenges the will. If he does not challenge the will, then that indebtedness is null and void. So basically what it forces is the son, who might have had the thoughts to go ahead and to challenge the will in a bezdin, if he comes to a bezdin, they pull out this note of indebtedness and says, listen, if you challenge the will, your daughter, your sister is entitled to $10 million. That's greater than what the estate was. So basically it forces him to abide by the will. Again, there's other, different things that appear in that will that you see in the back of that thing. But this is the basic premise of it. The basic premise of it is to come up with a halachic mechanism to force someone to go ahead and to abide by the will. Now, some people get scared off. They want to, all of a sudden you said, I'm indebted to my wife, $10 million, I'm indebted to this one. They're uncomfortable with it. They, you go to a will, you go to a lawyer, they rely on the lawyer, the rabbi doesn't trust as much. They don't know, they don't understand it, they're not sure, they're not confident in the understanding the document. So if you look actually in that shtar, it says that it's only valid if produced in a bezdin and not in court. So that basically could put some people at ease. They're uncomfortable with the direction of such a star. The will is still in full force. If they go to court, the will will be 100% enforceable. If they try challenging this will and they try going to a bezdin, we have this star. So that's a way that someone could go ahead and to protect himself on both ends, both from the halachic perspective and on the legal perspective.
Can't they challenge it in court, the will itself?
They could always challenge, but that you go to a lawyer for it, hopefully wrote it in the right way that it shouldn't be able to challenge it. Again, everything can be challenged. There's no guarantee to anything. But the job of a person is to set up his estate in the way that it can be reasonably expected and nothing should get. It's very rare, I've yet to see it, that this star was challenged. I've been a Dayan for over 20 years. I've never seen this star challenged. At the end of the day, they see the writing on the wall. There's a will that's enforceable in court. So, again, can you always make the argument that maybe the person wasn't sound of mind at the time of that, and the person when he wrote the will, yeah, there's always challenges. There'll always be some sort of disagreements. But the challenge on the merits just of a will or the merits of this star, I have not seen challenged. Again, there'll always come the day, and we'll see what happens. But usually, you did your job if you write the star. If you wrote a will, you went to a lawyer, and you went to there are lawyers that are knowledgeable in this, and you don't necessarily have to go to a Rav to have this enforced. There are from attorneys who are knowledgeable in this type of a star and could actually produce it. Again, sometimes if you have a particular question as to what's the proper way to set up your estate, it might be advisable to speak to a Rav. But there's even a do it at home way of doing it. There's a sefer you pick it up at most farm stores. It's called Kuntras Midor Lador, which is from Rav Feivel Kohn, which actually has this star, a similar type of idea, and it has a line-by-line instructions exactly how to fill it out. It has all the proper forms there, and a person could do it on his own to fill out this form. And again, as we mentioned earlier, I can't underscore this. I'm going to end with this. It's very important for someone to be proactive. Someone should not just rely that his kids will do the right thing, that there won't be any machlekes. You worked your whole life to do for your kids. Make sure that your life's work doesn't get undone by the uncomfortability by some people of going to that lawyer and to writing up the will. It's extremely important that someone should go write a will, and that's the most important thing. It's advisable that someone besides a will to go ahead and to write a halachic will that will make that will upheld and not be able to be challenged. And if a person goes ahead and does these steps, that there'll be shalom and there won't be any strife in his family. And again, it's something that's simple, easy, and quick, and something that's kedai to go ahead and do. Thank you. Yeah.
Is it advisable, is it a good idea or not a good idea to call all children down and tell them what you're putting in the will?
Not advisable. Children should know their place. Children should not think that they should be telling their parents how to divide their money. Parents tell their children how they're dividing their money. And they should not know, and they should not be involved in saying, you do this, you do that. I'll speak to my rabbi, I'll speak to my attorney to make sure that it's done right. And a child should, it's not the child's money, it's the parent's money. And parents should not afford the opportunity for their children to try to influence them. This one saying, oh, you know what I did for you, this, that, I think this should be done, never done. Do it the way the Torah said. Give all of them equally, and you won't have any machlokes. There's no reason to have your children involved, and I would definitely strongly advise, unless there's a particular situation which might need it, that the children should not be involved in seeing the will, knowing what the will says. They'll get what you gave them, and that's a difference today between a child and a parent. The parent is in charge, and the child should listen to what the parent told them.
They should not see copies of the will during your lifetime.
I don't see any reason for it, unless there's a specific reason that they have to. Sometimes it's necessary, but there's no reason.
Let's say one of the children is going to be the executor, and there are trust funds in the family. You have to educate until they know what's going on.
Exactly.
Okay. Again, if there's a need to educate, then it could be okay. But not because you're giving them an idea as to what you're doing and giving them the ability to challenge anything that you did. If there's a practicality in it that you need to be, but even that, I'm not sure what usually a lawyer will delineate what the point of the trust is and give the executor his instructions as to how he wants the trust divided, who the beneficiaries are, and what they should get. I don't see any, but if there is a practical reason, it's okay. I'm not trying to say that it's wrong. What I am saying is it's not necessary to involve the children in a way that they should have sort of any way of deciding how the estate should get set up.
There's a big difference also the age of the child. When you're talking about an adult,
Okay.
Giving the opportunity, I agree with you saying you have to educate them so they understand exactly, what your real wishes are.
I don't see why that can't be written.
This is what you're talking about. This is
I don't see why it can't
a
be.
big problem,
Okay. I've seen many a time where parents started discussing it, and the children then convinced and got the parents to do things that were very wrong.
It's one thing to tell the kid was gonna be the executor or the person
According
representing.
to your expertise,
It's another thing.
if somebody videotapes or records on video a will, does that stand up according to Halacha and on in court?
So if it would stand up in court, then you might have make the argument that it should stand up halachically based on the concept of mitzvah l'kayim divrei hameis. It might not, depending on who you told it to, depending on, if you will look in that case. But it's definitely something that should not be relied on.
Also one of the reasons that you kind of need to go by a secular will very often is because of the estate tax laws.
Of course.
You could save millions of dollars for especially
Correct.
tax people. There's the marital deduction, which automatically
100%.
goes to the wife, most of it, except what's allowed to the children. Because you save, literally, there's an exemption that each could have.
Yeah,
If
I'm
you
well
don't give
aware.
half to the wife,
Correct.
you're going to end up giving millions of dollars to the government.
It's
So
definitely
it's really important
correct.
to do that. Why give extra $5 million to the government when you could go to your
That's
children?
definitely true.
You talked about the carve out where you said you can change, you can do the carve out according to halacha, but you said because of the expectation, people will feel they follow the Torah way the daughter would expect.
Right.
The
So-
carve out itself is going to be
Right, but the
unfair.
carve out
Why would
itself,
that
when you
cost
take a
like
$5,000-$10,000 and they understand that you're doing it because that's what the Torah says. If the children are going to be challenged and have machlokes for that, they probably have much stronger issues. I mean, it's not something, we're not talking about, taking the estate. You're taking a small amount of money. And that people can accept that I'm doing it because that's what the Torah wants me to
Also,
do.
you mentioned that the government doesn't care how you portion the money.
Correct.
That was not my experience in Maryland. Where my father was, the lawyer told us the wife has to get. That's the law. You cannot exclude the wife. So I don't know if that's always true.
Again, maybe I made it too broad into that interpretation. There's a house, there's the main thing. There are certain assets which maybe they can't, and then you could start making the argument on those laws. But yeah, what you're saying is correct. I didn't mean, maybe I painted too broad of a brush, in saying that there could be definitely certain things that could fall under state law that have to be given certain way.
Is there any difference with a bachor?
So, according to the Torah, we didn't address that, but a bachar does get pishnayim. He gets not a double portion of the entire estate, but an extra portion of the estate. So, say that there were 5 kids, you would actually divide it by 6, and he would get 2 portions, 2 out of 6. You get a third of the estate, and that's something also. If you do not change what the Torah says, he will get that. But again, when you're setting up a will, there are many rabbanim that say the same way we sort of making everything equal to avoid machlokes, that they'll encourage people to give equal and to sort of take away the bechor, except in that carve out where he will get a double portion in that carve out, because that carve out is going to go exclusively the way the Torah is set up. The Yerusha should be set up forth. There are those who say, depending on how many children you have 7 children, and it's only an extra percentage. It won't necessarily become machlokes. So that depending on who you ask as to whether or not it's proper to leave a chelik of bechor or not.
Parents have dual citizenship in the United States and Israel. And you write your will in the United States. Does the state of Israel have any standing on a dual citizenship situation?
I don't know.
And,
I'll be honest with you, I don't know.
Okay.
I can't say that our Bezdin is recognized by the state of Israel, and people come in all the time to solidify the agreement that they have with that and that, but as to whether or not how they will go, that I'm just unfamiliar.
The United States has treaties with most countries that they recognize that the will was appropriate here will be recognized in a foreign state.
Well, it's tax treaties.
No, it's also looking at, there's generally, between states and governments, a will that's good in one country, as long as it's done properly here, is generally recognized, except for
You
taxes.
can
are a
write
different
that,
thing.
and that's basically what it's done. That's basically that is the concept of the way it's done. Is that we're saying that there's a note of indebtedness that if they challenge the will, that person will be. And if you look at the shtar again, I couldn't explain it fully because it's not for now. But it's a very technical thing. If you have multiple kids and the one who challenged it will lose, not at the expense of the other one. If you look at that type of, if you look in the back of the book and you look at the shtar, you'll realize that it's done basically in effect that that's the way it's done.
A couple things to touch on real quick. Going back to the video the next gentleman brought up, if it's attached with a dying man's declaration, isn't that honored in court?
Again, what I said is that if it's honored in court, it's the same as writing a will. I'm fine with that. But again, why discuss something of doing it in a way which is, go to your lawyer, make sure you do it right, and don't rely. I would even recommend not doing an at-home will. I've seen some of those that were messed up. Go to an attorney, spend the money, do it right. And if the attorney says it's good for me too.
And, sorry, just, the other point, you did briefly gloss over it, but just so it's more understood by everyone, doesn't it say in that rule that the daughters will need to have the estate?
Sorry, I didn't hear what you said.
Daughters are need to have the estate.
Daughters live off the estate.
The daughters, not, there are minors under a certain age which are entitled to live off the estate, but once they reach a certain age, they don't get from the estate. There is a concept we call ksubas benin dichrin, which is that if the parents married off some of the other siblings and they gave some money, we'll give a comparable amount to the next children. Again, I can't cover every aspect of it. There will be. I'm trying to give a general thing, outline just what the problems are. Yes, when I said the daughter doesn't yarsh, she doesn't yarsh it, but there are other takanas of why she might get. There are certain monies which she might be entitled to, but again, that's something that should be dealt with in a simple way and not rely on her getting money from those sources.
If it's a second marriage, and Halacha does the wife voice, if he doesn't write the will, does the wife voice get also?
His stepchildren will get nothing. Nothing. Zero.
Zero. Thank you.
Greatest typist does not require ethos.
Sorry, I couldn't hear you.
The greatest typist does not require ethos. The journalist typist.
Correct.
The signing of witnesses, the woman being a neighbor to say that the husband was
Sound of mind, correct.
And therefore that does necessitate that those eight are kosher ethos. In the strict sense of the base
Correct.
woman that can be not Jew.
It's advisable to have proper aid.
What
If you're ever going to get challenged, like you said, is it a signature? How many times will it come say, you have the original copy? Do you have the original copy of the will? Or it's a copy of it? Is a copy acceptable halachically? If they're witnesses, they could testify to it. Sometimes they are, sometimes they're not. You can Mekayim der Chasima. The way definitely it's an added enhancement to be able to Mekayim the will. It's an added halachic enhancement. It's an added halachic enhancement. Being able to prove something is a halachic enhancement. It's not necessary, but it's an added.
Is there a concept of a notary in Halacha?
Notary could be as good as the person who's the notary.
No, but I mean.
I understand what you're asking. He can't be more than one person. The Torah says one aid, two aidim, so he's maybe a more trustworthy person, but doesn't make him into two aidim. He's still not one. He's one person still.
It's a woman's estate, different, she's a single.
So, not really. I mean, a woman's estate, there's no bechor. There's no bechor doesn't get a double portion in a mother's estate, only in the father's estate. But that's more or less the only real difference.
in a Bais Din proceeding in general, will the Bais Din consider a witness who's not halachically qualified as a witness?
No, and yes. No, in effect, is they won't consider him a witness. We still have the Torah and we abide. The Beis Din's mandate is to judge according to what the Torah says. At the same time, someone who's not a qualified witness will often be brought into the Beis Din, either guy or anyone else, because they set and they bring out points as to what the story happened that could be challenged, that will give the Dayanim a feel as to what really happened, and they could judge according to that, but they won't have a halachic status as a witness, but we still bring them in very often in order to be able to deal with the things that happen of what based on what he said.
So if you have one of those witnesses and a halachic witness who are giving you
again, if the halacha would need two witnesses, at the end of the day it won't be two witnesses. If the Beis Din is able to adjudicate based on understanding and is given certain rights, very often the way the arbitration agreement is that they have a concept of pshara, so they could rely on those witnesses and for such a thing. But at the end of the day, the Torah is very clear as to who's a witness and who's not a witness, and that didn't change.
So I guess I'm not 100% sure what you just said.
What I'm saying is that there is ultimately he's not a witness. That ends that. He's not a witness. But we definitely will take into account his testimony to the extent that we can halachically. That means different situations will let us take into other variables into account, but he's not valid like a witness.
At the end of the day, when you make your judgment, the fact that one of them is a halachic witness and testified a certain way, you could still find against him,
right,
based upon that overall.
Now, if there are two Eidim that say a certain way, the Beis Din might not have the mandate. Again, there's a lot of technicalities that go into that's a per case as to how to deal with the proof that's brought in the Beis Din.
Okay, I'm sorry. So a bakar, even if someone's not technically a bakar, so he's not entitled to double. Let's say he is a girl before him or someone, so he's not entitled to double. Now, if you do the carve out, let's say you decide 10,000 is carved out, is girl, boy, boy. Basically, the girl gets nothing and the two boys split the 10,000.
Correct. What is usually written is that carve out should go according to the code of Jewish law.
Right, that's what I'm saying, the carve out. So
the carve out, so the Bechar won't get anything. If there's a Bechar, he'll get double.
It's between a girl and two boys, doesn't two boys yet.
Correct. Okay.
Are you aware of any situations where a civil court has been overruled by a Bais Din in the United States? Has that ever happened?
What do you mean overruled?
Like, the civil court found this, kids or somebody challenged in the Bais Din and found something else and overturned the civil court? Can that happen?
It won't usually overturn. What happens is usually a Beis Din will only take a case generally if the parties sign an arbitration agreement, and the courts will honor that arbitration agreement. So technically, can it overturn? Yeah, if you have a judgment and you brought new proceedings in front of a new body and you gave them the right to undo what it said before, so then they could undo it on a technicality because you gave them the right to do it. So, if you sign an arbitration agreement and you want to relitigate something, then you could relitigate something. There's nothing against the relitigating something. Okay. Thank you.
Thank you. Beautiful. Thank you.